good evening to everybody. That the aspirants of the last PGLCET 2022 and Karibu Sana, welcome to our class. Please read what I posted on the screen. Anyone can unmute and read.
Multiple choice questions, MCQ, short notes, public international law. Professor Dr. Mohammed S. Hussain.
Yes, that is the thing. It's my name. So without wasting the time, let me go to the yesterday's class continuation, and today also the public international law. And we are at 25th question, which is not among the state territory. That is the personal territory, community territory, temporal territory, free territory. We discussed this thing yesterday class. So recap it is.
Temporary territory, sir.
It is a temporal territory is not there, not among them. That the personal territory is there, community territory is there, free territory is there. Okay, next 26th question. Who differentiate territories into 4 types? A, blower, B, brower, C, brony, D, blony.
Brownie, option C, sir.
It is the option brower, B-R-O-W-E-R. The B, B-A-G bag B. Brower,
Yes, sir.
differentiate the 4 types of the territories are there. Okay, now it's 26th question. What is the exact sequence or correct sequence of the following? A, community territory, personal territory, free territory. B, free territory, personal territory, community territory. C option, personal territory, community territory, free territory. D option, personal territory, free territory, community territory. Which one is the proper sequence of the territories?
Option A, sir. Community territory, personal territory, free territory.
Wrong.
Option B, sir.
No.
Reverse order. Okay.
It is a C, personal territory, community territory, free territory.
What does it mean, sir, actually?
See, they divided it territories. They say, first one they say personal. After personal, they will go to the community. Then after community, they go to the open, free. So that's why they made it in that fashion. Blower has made such a thing. And 28th question. The article which lays down those international conventions should be applied while deciding the dispute is A. Article 38 1A of the ICJ, B. Article 38 1B of the ICJ, C. Article 37 1A of the ICJ, D. Article 37 1B of the ICJ. What is the question? The article which lays down those international conventions should be applied while deciding the dispute. International conventions should be applied while deciding the dispute. So ICJ, that is the International Court of Justice, The Hague, Netherlands. So here the answer is?
Option D, sir.
No.
71A. Okay.
It is Article 38 1A of the ICJ. That is the option A. It is an option A.
Yes,
so next, 29th question. Can anyone unmute and read?
The doctrine of qualified neutrality was developed by option A, Bailey, option B, Victoria, option C, Gentilis, option D, Hugo Grotius.
Shoot, even though it is wrong.
Option C, sir, Gentilis.
No.
No, sir. Never heard about it, sir.
Yeah,
Don't have
doctrine
any
of
idea.
qualified neutrality was developed by the Hugo Grotius, option D. And we
Okay.
studied Hugo
Sir.
Grotius belonged to school, natural school.
Positive natural skill. Okay. Sir.
And that is also said as a
Can you
classical
repeat
school.
it? Yes.
Okay, now let us 30th question. In which of the following cases Justice H.R. Khanna in his dissenting note expressed that when there is a conflict between the municipal law and international law, municipal law should be upheld? A. R versus KN. B. ADM Jabalpur versus Union of India. C. Trickett versus Bath. D. Bowat versus Barbute.
Yes, sir.
Answer is
Option B, sir.
ADM Jabalpur versus Union of India. It is
Yes, sir.
the option B is the right answer. Union of India, not Indian. India. Okay, now next. Read the 31st question.
Much of international law is derived through analogy from option A, Islamic law, option B, Christian law, option C, Roman law, option D, none of the above. None of these. Yeah. International law. Roman law, sir.
It is
Option
the
C.
Roman law. The most of the international lies from Roman law because the first civilization is Roman civilization. Next, French. Next, of course, it has come German and other. Yes, now you have exceeded the free daily limit of the door close. What more? Okay. Now let us see the 37. His basic right. B. Option is not his right. C. Depends on circumstances. D. None of these. They say
C, sir.
basic right.
Depends on circumstances.
Yes?
Depends on circumstances, sir.
No, because when the people has come for the asylum, naturally, human right law says they should not be denied. But I doubtful how could it become a basic right to them. So perhaps it is a basic right to them because they came for the asylum. Asylum in international law, the protection granted by a state to a foreign citizen against his own state. The person from whom asylum is established has no legal right to demand it. Yeah, he's not real right to demand it, and the sheltering state has no obligation to grant it. So, in such a situation, the answer must be
Depends on circumstances.
depends upon circumstances. The answer is it depends upon the circumstances is the answer because even a grand states he can deny also and he can only request. So depending upon circumstances, they will give the asylum. Perhaps that will be the quite correct answer. Okay, 33rd question. 33 question. Which of the following cases has elucidated the retroactive effect of recognition? Option A, Mikkel versus Sultan of Johor. B, Civil Air Transport INC versus Central Air Transport Corporation. C, Duff Development Company versus Kelantan Government. D, Rich versus Navira, Yacuba and Republic of Cuba. Retroactive effect of recognition. In which case law it is decided?
Pass, sir.
It's a Duff Development company versus Kelantan government. In that case law, it is that retroactive effect of recognition. A recognition of the state, retroactive, those say. Okay, now say 34th question. 34 question. According to which article of UN Convention on Law of Sea, ships of all states, whether coastal or not, shall enjoy the right of innocent passage through territorial waters. So now option is A 12, B 14, C option 18, D option 16.
Option 16, sir. Option D.
No. The right of innocent passage through the territorial water, it is a 14. That's the B is the answer.
Yes, sir.
Article 14 of the UN Conventions that innocent sea water you can sail. Okay, 35th question, 35 question. One of the following number of the UN General Assembly has veto power. It is easy question. A. Australia, B. India, C. Germany, D. China.
D, sir. China.
It is China because veto power only permanent member of the Security Council, that is the five states would have the veto power. Okay, 36th question. Unmute and read.
Permanent Court of International Justice was established under option A, League of Nations, option B, UNO, option C, European Union, option D, none of these. League of Nations, sir. Option A.
In the beginning of the UNO, there was a League of Nations was there. And
Yes.
the League of Nations, they created or established the Permanent Court of International Justice. But once the League of Nations is over, eclipsed by the UNO, then what court is established?
ICJ.
ICJ. Where is the headquarters of the ICJ?
What talk? The name is not.
Hague, sir.
The
Hague,
Hague.
sir.
Hague,
The Hague.
Netherlands. I have shown the photos also. Okay, now next is 37th question. Truce. Truce. Truce means a temporary arrangement between the belligerent parties of the cessation of the hostilities. B. Any peace treaty to end a war. C. No war pact. D. None of the above.
Option B, sir. Any peace treaty to end a war.
No.
Then option A.
A is the right answer. A temporary arrangement between the belligerent parties for the cessation of the hostilities. Next, 28th question. The dash theory believes that the state law involves the rules of a single state, whereas the international law involves the legal system of a multiple states, and hence this theory is sometimes known as the dash theory. A, because two dash are there. Soloist and pluralistic. B, monoist and multicast. C, dualist and pluralistic. D, dualist and multinational.
Option B, sir. Mononist and multicast. Option
Option
B.
A, sir. Option A.
No.
Option B, sir.
The right answer is C. The dualistic theory believes that state law involves the rule of a single state, whereas the international law involves the legal system of the multiple states, and hence this theory is sometimes known as the pluralistic theory. Do you know dualistic
Achha, so-
theory, monolistic theory? It comes under statelessness. And of course, it comes on the Grand Nam also comes over there, legal, and another theory also there, because the four theories will make the statelessness. Okay, now let us see 39th question. On one hand, we can say that international law is the law of the nation. I repeat, 39th question. On one hand, we can say that the international law is the law of the nations. On the other hand, the municipal law is known as the dash. A. Internal law of the country. B. Internal law of the place. C. Internal law of the boundary. D. Internal law of the land.
Option A, sir. Internal law of the country.
Law not
Option,
about the country, always
option D,
law
sir.
is about the
Option D,
land.
sir. Option D, sir.
Option D is the right answer. Internal law of the land. And the international law is, it can be made as the law of the nations. And the municipal law means domestic law, means law of the state. So it can say the internal law of the land. So that is the right answer. So 40th, anyone can unmute and read?
The word asylum is a Latin counterpart of the Greek word asylon, which means option A, freedom from seizure, B, liberty from seizure, C, freeness from seizure, D, out of seizure. C, sir, freeness from seizure.
Freeness,
Option C.
legal terminology is not there.
Okay, out of
Freedom
liberty
from seizure, sir.
Freedom from Caesar. A is the option. The
Okay.
word asylum is the Latin counterpart of the Greek word asylum, which means freedom from the Caesar. A. A is the right answer. Yes, 41. Indeed, the right of asylum has been said to compromise certain specific manifestation of the state conduct. Which one is odd man out? All three belongs to the above statement, but not one. Which one is the answer? A. To allow a person to its territory. B. To allow the person to sojourn there. C. To refrain from expelling the person. D. To refrain from the extraditing the person. Which is odd man out? Shoot. I have shown the feedback also.
Option
Nobody
B,
has
sir.
seen it. Immediately drawing down. I scroll down. Yes, anyone?
Option B.
D,
To
sir. D.
admit a person to its territory. To allow a person to its territory. Which is odd man out. So instead of to admit, I wrote to allow a person to its territory. So odd man out is A. Now 42nd question, 42. The three phases of right of asylum. Which one is not among the four? Number A, right of a state to grant asylum. B, the right of a state to admit asylum. C, the right of an individual to seek asylum. D, the right of an individual to be granted asylum.
Sir, yes, sir. A. The right of a state to grant asylum.
Answer is B, the right of a state to admit asylum. Court will grant it, state will admit it. Am I right?
Yes, sir.
Yes, sir.
And in the interpretation of the statutes, you might have read the language canons. In the language canons, redondo singula singulis, that is one of the canon of the language. Have you heard any time? Redondo singula singulis. Yes or no?
Yes, sir, we read about it.
And there it says, you can load the gun and you can draw the sword. But we cannot say you can load the sword and draw the gun. Is it clear?
Yes.
Okay, 43 question. Monist theory was developed by dash scholar. A, French, B option Italian, C option German, D option Australian.
Option A, French.
Monist theory. This comes monist theory, dualist theory, grand norm. This comes on the statelessness or stateless. Okay, supplementary question. How many stateless countries are there or clans are there in the world? Stateless. Of course, I will frame the question later. There are 5. I will speak it later. 44th question. Which is one wrong statement among 4? 3 are right statement, 1 is the wrong statement. Number A, option. Monist theory was developed by German scholar, namely Moser, Hegel, Bregborn, John, Wengel in the late 18th century. Option B, 19th century by Wright, Kelsen and Duguid. Option C, it is believed that the international law and municipal law are the aspects of the one legal system. And the last one, option D, is they are different to each other. Which one wrong statement among the 4? 3 are right, only 1 is wrong. Monist theory was developed, yes, it's true. It's the German scholars, they developed this theory. Moser, Hegel, Bregborn, John, Wengel, the late 18th century, that is. Even B also right, B century, that is the Wright, Kelsen and Duguid. And the C, yes, it is also correct. It is believed that the international law and municipal law are the aspect of one legal system. And the D, they are not different to each other. They are not and are not different to each other. Means monist theory says international law and the municipal law are the same legal system. That is the monist theory. Of course, dualistic theory said they are a little different would be there. Yes, unmute and read the 45th question. 45 question.
Ground norm. 45th question. Ground norm. Theory propounded by option A, Hobbes, option B, Hugo Grotius, option C, Kelsen, option D, HLA Hart. HLA Hart, sir. Option D.
No. Grand norm theory is a very famous theory. Because
Option B, sir. Go Grotius.
no.
Then it has to be Kelsen, sir.
It is the Kelsen who said grand norm is a constitution. If any other statute which are in contravention with the constitution and that statute is void, null and void. So Kelsen has developed the grand norm theory. The next question is 46th question. Kelsen belong which country jurist he is? UK jurist, USA jurist, Austrian jurist, or Australia juris?
Option C, sir.
It
Option D,
is
Australian.
option C is the right, Austrian. He is a
Australian.
jurist of the Austrian, but his contribution is very much good in the jurisprudence as well as the public international law, including the private international law. So now let us see the 47th question. Dash of the Vienna Conventions on the law of treaties prohibits the state from invoking its municipal law as its justification for non-obligation towards the performance of treaty. Article 25, A option, B option Article 26, C option Article 27, D option Article 28 of the Vienna Conventions of the law of the treaties.
Option A, sir. Article 25.
It is the option C, Article 27 of the Vienna Conventions. The law of treaties prohibits the states from invoking the municipal laws. So, naturally, in the law of treaties, what are the agreements should be there? What are the norms should be there that would be followed? That is the treaty definition, a treaty. But the municipal law will not be followed. But when a matter comes to the private international law, again, we will see that if the treaty is silent, then the municipal law, connecting factors, principle of general principles of the private international law, and there is another point also there. Objective theories will be followed. Comity theory is there, local law theory is there. Of course, we don't have the private international law in our syllabus, hence we need not worry about that one. So now 48th question. The relationship between the international law and the municipal law can be mainly explained by the two principal theories, namely, number A, monism only, B, dualism only, C, monism and dualism, D, all of the above.
All of the above, sir. Option D.
See, when you look at the option, find out which one is improper or which is proper. See, when you say all of the above, you can say monism only comes and dualism only comes. But if you say C, monism and dualism comes, then which is the appropriate answer?
C, sir. C.
You should be C. Don't say D. You lose the marks.
C. C, sir.
It's the C. Option C is the right answer. You cannot reap unless you sow. Did you get my point?
Yes, got it, sir.
You cannot harvest unless you irrigate. You cannot think about the name of a boy or a girl unless the wife is delivered and a viable baby. Means baby should be alive. So 49th question, read it.
Yeah, which one is correct
Sir,
statement
Question-
among the
question-
four?
Sir, please get along, please.
Yeah. 49th question. Which one is correct statement among the four regarding dualism theory? Option A. The chief exponents of the theory is Azilotti. Option B. The chief exponents of this theory are Azilotti, Hersey, Lutterpach. Option C. The chief exponents of this theory are Hirsch, Lutterpach, and Trepel. Option D. The chief exponents of this theory are Azilotti, Hirsch, Lutterpach, and Trepel. No, sir, pass. Don't have any idea.
See, I made only one author first. I made the two authors second. I made third and fourth author. Then the last I made first to four. If you use the logic, which is the right answer? D is the right answer.
Okay, sir.
All four are present there. So number one is wrong. Number two, only two are present there. Number three, only two are present there.
Yes.
Means third and fourth. But
Yes,
number
sir.
fourth, there's the D option. 1, 2, 3, 4 are present. Because they are the persons, those who are standing for dualism. Unless until you know there are four members, you cannot answer that question.
Yeah, there is a problem, sir.
Yes, unless until you know the four members are the persons, you cannot answer the question. But logically, if you just use your brain, you can directly shoot D. Are you clear?
Yeah, got it, sir.
Yes. 50th question. The Supreme Court also made it clear that international customs and norms which are not contrary to the municipal law shall be deemed to have been incorporated in the domestic law. In the landmark case of Dash, the Apex Court clearly stated that if there is not a law regarding any subject matter in Indian law, then the reference can be taken from the customary international law. What is the case law? Where the customary international law is recognized over there and it is followed. Number A, Vellore Citizen Welfare Forum versus Union of India. B, Vishaka versus State of Rajasthan. C, PUCL, that is the People's Union CL. This is the organization. This is a communist organization. PUCL versus Union of India, and the Shin Kumar Sharma and other versus Union of India. Among the four case law, one is the landmark case law where the custom will be used over there. We can use the customary international law.
No,
Yes?
sir. Pass. If I guess, I should say B, sir.
B is the right answer. In the Vishaka is a very famous case law. In the Vishaka case law, they said citizen only given the protection for the rape is not the question. Any human being. When you say any human being, then legal instruments, international instruments comes into the picture. And that is the reason we can say is a landmark case law where the customary international law is used over there. Because it is not anyway contravened with any domestic law. So the same thing said. The Supreme Court also made it clear that international customs and norms which are not contrary to the municipal law shall be deemed to have been incorporated in the domestic law. So rape is not only to the citizen, rape to any human being. That is the Vishaka case law has come.
Sir, is the Geneva Conventions?
No, because there are many conventions are the international, either conventions or protocol or treaties or charters. Human being enough on the earth planet, the inherent rights are given to the human being, irrespective of the caste, creed, color, language, skin, and mode of living. So that is the human rights law coming to the picture over there. So 51, stateless means dash. Which one is correct statement or answer? A option. Stateless person is a person who is considered as a national by any state under the operation of its law. B option. Stateless man is a person who is not considered as a national by any state under the operation of its law. C option. Stateless man is a person who is not considered as a national by any state in the operation of its law. And the D. Stateless person is a person who is not considered as a national by any state under the operation of its law. Only one is the correct answer. All are wrong.
Option D, sir.
Option D is the correct answer. Stateless person is a person who is not considered as a national by any state under the operation of its law. But other things I made. Stateless man, I said. No, it's not man, person. In other place, a stateless man is a person who is not considered as a national by any state. Then I made the different way there. So each place you could find a different wrongness is there. And the first one, I say who is not, I remove the not. In the first one,
Yes, sir.
who is not. So just to use the logic and see that how it can be make it out. If you are two places you are one, automatically you can know that other two option in the other two which is the best option, because you eliminated it. So deductive method you followed over there. So here the what is statelessness? The international legal definition of the stateless person is a person who is not considered as a national by any state under the operation of its law. In simple terms, this means that stateless person does not have the nationality of any country. A stateless person does not have the nationality of any country. So 52nd, statelessness may result from a variety of the causes, including the following, but not one. Three are causes for the statelessness, and one is not the cause for statelessness. Option A, conflict of laws. Option B, the transfer of territory. Option C, marriage laws. Option D, contract laws.
Option
A,
D,
sir.
sir. Contract law.
A, sir. A.
No, conflict of laws are there. Yes, it's a statelessness. But contract is not there.
Yes, sir.
And the transfer of territory is there where the stateless will come into the picture. But in contract, there is no statelessness will come into the picture. Because in contract, two human beings are allowed, it is enough. Am I right? But the two human beings should be sane persons and having the capacity to contract. Is it correct?
Yes, sir.
Okay, now let us see the 53 question. Read, unmute and read.
Statelessness may result from a variety of causes, including the following, but not one. Find the odd man out. Option A, administrative practices. Option B, discrimination. Option C, lack of birth registration. Option D, nationalization. C is a lack of birth registration. Option C.
Statelessness may result from the variety of the causes, including the conflict of laws, the transfer of territory, marriage laws, administrative practices, discrimination, lack of birth registration, decentralization. I wrote nationalization. What should be the appropriate word? Denationalization. When a state rescinds an individual's nationality, and renunciation when an individual refuses to take the other nationality. And I told you, 5 countries or ethnic groups are the people, even still now, they are stateless. Who are they? But the Indians should have to know it, because you are India. Buddhist genocide.
Aung
Whom?
San Suu Kyi. Aung San Suu Kyi, sir.
Rohingyas.
Rohingya.
See, there are 5 states in world which make it out statelessness. Here I have made it. Oh, this is the another one. Okay. Here I made it. The 5 stateless groups, not countries, groups. Rohingya, Roma, Nubians, Baiduan, Yao. And these Rohingyas you know better. Where they are?
Hyderabad. Hyderabad.
Hyderabad, Rohingyas.
West Bengal.
They came from
West
where?
Bengal.
Rohingyas are the group of Muslims of South Asian descent populated Western Myanmar. The Myanmar genocide the Rohingyas, so many of the Rohingyas reached to the India and Bangladesh. And Myanmar government pushed many Rohingyas out of the Myanmar, which is how they ended up in Bangladesh, other nearby regions, and Myanmar, dominantly Buddhist, does not want to accept the ethnic group into their nation. So Rohingyas suffer from the intense discrimination, hatred, and unkind deaths. With no one to support them, Rohingyas are completely dependent on foreign aid. Next is Roma. Their Roma is origin unknown. It is certain that this group people arrived in Europe prior to the 19th century. Prior to the 19th century, these Roma people entered in the, and historically many Roma were forced into slavery and sentenced to death throughout the medieval era of the being helpless, and alongside the Jews were prosecuted. Then another is Nubians, originally from Sudan. The Nubians were brought to Kenya over 150 years ago when the British government asked them to fight in the colonial army. These Nubians, they have not been able to return home. They did not go to the Sudan. And today, Kenya will not grant a Nubians basic citizenship rights. In their Kenya is their Nubians. And another is Baiduan, the Bidun. That is the quiet people. It is one of the stateless groups attempted to break free from the status of the illegal residents. Badayun will say something in the Arabic, Badayun. And descended from the Badayun people and desert dwelling people and Arabic ethnic group, but the Kuwait still they did not give it. And the Yao is one of the main Thailand hill tribes is Yao and don't have the Thai citizenship. And these are the groups still it is stateless. But in 2024, UNICEF assured them that they will see that they would get the citizenship of a country where they belong. So there are 5 groups are there which are not having the nationality. And we said, which are the 5 groups? Rohingyas, Roma, Nubians, Baidin, and Yahoo. Is it clear? Is it clear?
Yes, sir.
Very good, very good. So now, in the next class, we will see, what is the next class? Mercantile law. It is the 16 questions. I will intimate you whether the same timings or different timings, because our examination starts from Monday. Sometimes exam is 8 o'clock, sometimes exam is 12 o'clock, sometimes exam is 4 o'clock. At that instance, for me, it's difficult to take the usual time this time. Perhaps the old time will be the holds good or not. I will inform you. The old timings are Indian time 9:40 p.m. to 10:30 p.m. That is I fixed over there. By that time, I don't have any other duty, but it is only the night. so I can deal it comfortably. So tomorrow class I will make you in advance whether I will take at 6:10 of India time or 9:40 of the India time. Is it clear? Say yes.
Yes, sir. Thank you, sir. Thank you very much, sir.
So with this, I would like to stop my sharing today. I am sure that the time is also going to up because now the time is only 2 minutes are left. And if anybody wants to ask anything, you can ask me.
So once again, wish you happy Bakrid, sir.
Okay, thank you very much. And because I am staying in the foreign country and here I did not have that much relatives here, because if it is in Dar es Salaam where I stayed the more than 13 years, at least some of them I knew them. And here I came only 3 months before, so very few people are there to whom I knew him. But where there is a masjid, he is there near to my house, rented house, so I can go and pray over there. And afterwards, then I will see, because one of the Indian also working with the family, my best friend Puluru Sachinarana, he is also there with me in the working the same university. If possible, I will invite him, both the wife and husband, to come and have a lunch with us. If it is they accept, well and good, or at least I can say to any one of them to come, Pullur Sachinaran, to be with me. So that is only the thing that we would make it out. So with this, that I would like to stop my today's sharing. And the tomorrow class that we are going to deal is the mercantile law. And the mercantile law, you have to read the class and come to the class before my fourth option is read over there. You have to shoot it. So that is the sharpness which will be shown when you read the mercantile law. Okay. Thank you very much for your patience.
Thank you very much, sir.
And I will see you tomorrow, but I will intimate that tomorrow what time is that I am going to take the class. I told you already that if one person also get benefit of my mission, and I will feel that my mission is fulfilled. With this, I would like to stop screening.
Great of you, sir. Thank you.
Yes, the end of the meeting for all. End meeting.
Tanzania,